I'm Drew Stevenson, and this is a discussion about the U.S. Supreme Court case SWANCC versus the Army Corps of Engineers from 2001. SWANCC is an abbreviation for the Solid Waste Agency of Northern Cook County. And here in this video, we're going to be talking about Chevron deference and federalism. And again, just by quick way of introduction, hopefully you're familiar with Chevron deference. In 1984, the Supreme Court wrote an opinion in the Chevron case saying that when a statute is ambiguous or unclear or maybe silent on an issue, that the agency that that statute is addressed to, or that Congress entrusted with implementing that statute, should fill in the gaps in terms of interpreting it. And that as long as they're being reasonable, courts should defer to the agency. And that's all well and good. And agencies do that every day, and courts defer to agencies under Chevron every day. But the question arises, what happens when we have other complicated constitutional concerns about, let's say, federalism or First Amendment issues? And in this case, we're talking about some traditional state functions about regulating pollution and things like that, and Congress's assertion of Commerce Clause power and other things that you really would discuss in your constitutional law class, and how that interacts with Chevron deference to an agency. So let's see what happened in this case. So our takeaway, or where we're going with our discussion here, is that there's some ambiguity about what this case really stands for, whether it's invoking the avoidance canon, or if it's suggesting almost a non-delegation type principle, not a full non-delegation doctrine, that courts should be reluctant to construe federal statutes as delegating to agencies the authority to alter the traditional allocation of responsibility between federal and state government. So remember, just to kind of clarify our terms here, the avoidance canon has had different variations in how it's expressed over the years, but the idea is that the court should interpret a statute in a way that it will survive a constitutional challenge, right? If a statute could be interpreted in different ways, why interpret it the way that is going to mean the statute has to be thrown out when we could interpret it in a way that fits within the Constitution? So again, the avoidance canon has been expressed in different ways over the years, but that's in a nutshell the common thread in all of its expressions. We also have a non-delegation doctrine from the New Deal era, which the courts don't really invoke very often anymore, but we've been told by the justices it's still there as a last resort, that there are some limits on how much authority Congress can delegate. And some of the reasons we don't often have to invoke the non-delegation doctrine is that there's other sort of interpretive principles that courts use the same idea from the non-delegation doctrine as maybe a way of interpreting a statute. So in other words, instead of a non-delegation doctrine like Congress isn't allowed to do this because it violates the separation of powers and therefore we have to throw out a statute, maybe we will take our non-delegation concept and have that framework as we decide what an ambiguous statute actually means or how to interpret the words. And one way of taking this case is that that's what the court is really doing. Okay, so let's go back and see what happens. The Clean Water Act gives the Army Corps of Engineers jurisdiction over dumping dredge or fill materials into navigable waters. And this is a phrase which in turn is defined in the statute as the waters of the United States. And so the Corps issued regulations that interpreted waters of the United States really expansively. And I have a little diagram from the Army Corps of Engineers here, sort of explaining the idea that when you have high water, even though you can't necessarily take a boat from coast to coast, a lot of different bodies of water do connect, or the marshlands between them connect. And so they said this includes, among other things, wetlands or temporary ponds that are used as habitats for migratory birds that cross state lines. And so SWANCC here is a consortium of 23 suburban Chicago cities and villages, and they needed a new landfill, right? Basically municipal dump. And the problem was, and they wanted to buy some gravel pits that were in a remote location. There was plenty of acreage, and use this sort of abandoned gravel pit as their new landfill. And the problem was that over time, these pits filled with rainwater and rainwater runoff, and they had become a habitat for migratory birds. And the Corps, the Army Corps of Engineers, refused to give the necessary permits, so this consortium, SWANCC, sued. By the way, we're calling it SWANCC because of the waste company that was actually going to construct the landfill, but it's a whole group of kind of co-plaintiffs here. So let's talk about the issues. There's a statutory question and a constitutional question in this case. The statutory question is whether it's reasonable to interpret the term navigable waters as including wetlands and temporary ponds that are there after a rainstorm. The SWANCC says no, because these small artificial ponds are not navigable. In other words, you can't take a boat, even a canoe, from one to the other to the other. There's dry land in between them. But the Army Corps of Engineers says yes, because navigable waters are defined very broadly as including all the waters of the United States. And the term navigable is just a term of art that means waters over which Congress has jurisdiction. So they're basically saying navigable is not being used in its sort of everyday meaning as like you can get a boat through there or a ship, but actually just basically it means all the waters within the continental United States. So the constitutional question here is whether the federal government really has power under the Commerce Clause to assert jurisdiction over non-navigable isolated bodies of water like these ponds. So this case is a little confusing for students, but some of you may have studied this in your constitutional law class. So let's talk about the holding here. Chief Justice Rehnquist writes the majority opinion and decides not to reach the constitutional issue, right? This question of whether the Commerce Clause actually even gives Congress the power to give the Army Corps of Engineers such broad authority. Instead, the majority rests on statutory grounds, concluding that even though this is a Chevron case, the Corps' interpretation of waters as including these isolated non-navigable ponds is unreasonable. In other words, this is one of our kind of rare cases where an administrative agency loses at Chevron step 2. And just to kind of take a break from the slides here, remember there's 2 steps to Chevron analysis. First, the court asks, is the statute ambiguous or unclear? Because if it's clear, the agency just has to obey the statute, right? But if it's unclear, and reasonable minds could come up with a variety of interpretations, then we ask, this is Chevron step 2, is the agency's interpretation is reasonable? And as long as it's reasonable, the court should defer to the agency, even if the court would have come up with a different answer itself, right? So if it disagrees with what the agency did, but the agency isn't being unreasonable, they're supposed to defer. This is a pretty easy standard for an agency to satisfy, right? Just don't be crazy. And so usually they win. If we get to step 2, normally the agency wins. And this is one of those kind of like big cases where the agency actually loses at Chevron step 2. So let's go back. We're almost done actually talking about this case. So the majority gives several reasons for this, but here we're focused on the application of the avoidance canon. And by the way, keep in mind, this had become quite a politicized issue, this definition of navigable waters, because it meant that the Army Corps of Engineers was defining a lot of privately owned land in the United States as federally protected wetlands and prohibiting any type of development or construction on these things. And so it had kind of become a talking point for conservatives in the years leading up to this case that somehow we had to rein this in. Rehnquist says the agency's interpretation of the Clean Water Act would invoke the outer limits of Congress's power under the Commerce Clause, and that courts should be reluctant to assume that Congress delegated such power to the agency. In other words, That would really be a stretch and would then make us start wondering if is what the Commerce Clause even allows, or if the non-delegation doctrine allows this. And so maybe we should just kind of assume that Congress wouldn't have done something so drastic. And so maybe we think he's invoking the avoidance canon here. But it also suggests that the concern is about whether the agency's interpretation is entitled to deference, um, if the concern is heightened where the administrative interpretation alters the federal state framework by permitting federal encroachment upon a traditional state power. Now, this is kind of he's saying maybe there's a twist on Chevron, that part of the reasonableness of the interpretation when we get to Chevron step 2 should be, it's unreasonable to think that we're going to, that an interpretation that allows the federal government to encroach on traditional state domains and traditional state legal functions is one of the permissible reasonable interpretations. So we have some highlights here. There's a question here about whether this is a just rhetorical window dressing to go with the avoidance canon argument. In other words, is this idea about federalism should be a step or a sidestep, or sort of a footnote to Chevron. Is this really just another way of talking about the avoidance canon, or is there something else going on here? And the court seems to be suggesting that independent of the traditional avoidance canon, a clear congressional statement might be required to authorize an agency to enact regulations that upset the traditional federal-state balance. So really, honestly, there are two possible interpretations of this case. The first is a narrow reading in which the plaintiffs, or the case, I'm sorry, the majority here, rightly or wrongly, is just following the Supreme Court's other case, which I also is in my casebook, DiBartolo, by invoking the avoidance canon to reject an agency interpretation that raises a serious constitutional doubt. And for my students, if you're getting confused, if you read DiBartolo and Russ v. Sullivan and this case together, you might feel like these cases are all over the place. And if that's your takeaway, actually you understand, right? That we have some uncertainty about the relationship of Chevron when the agency's interpretation involves a debatable constitutional point. And so maybe this is really just another DiBartolo case. Or a broader reading of this opinion would see the court as establishing that an unusually clear statutory statement must be required to authorize an agency to encroach on a traditional state power, even where there's no serious question about the constitutionality of the agency's action. So even if we decide that Commerce Clause allows this, if we're sort of cutting new ground in commerce, how expansive we're going to read the Commerce Clause, maybe we want Congress to spell that out really clearly. And Chevron, remember, Chevron step 1 is we're deciding that the statute is ambiguous. So maybe, and again, this is sort of collapsing the two steps of Chevron, maybe if the statute is ambiguous enough that we're even getting to step 2, then we shouldn't give it the benefit of the doubt that Congress is doing something really drastic or sort of unprecedented from a federalism standpoint. Okay, that concludes our lecture about this case.